For inviting us in. It's now 11 o'clock, and tonight there are more questions surrounding the Delphi murders as the Carroll County judge removes himself from the case. All of this follows several complaints from the judge about public and media interest in the sealed probable cause affidavit. So tonight at 11, we want to get right to Rachel Krause to find out what we know about the new judge assigned to this case. Rachel?
Yeah, and Scott, court documents show a Carroll County judge is recusing himself from court proceedings for one of the county's most critical cases. Richard Allen faces murder charges for his alleged role in the 2017 Delphi murders that killed Abby Williams and Libby German. Now, Judge Benjamin Diener has taken himself off the case, saying he didn't feel safe. The Delphi community spent 5 years waiting for an arrest in the case after the 2017 murders of Abby Williams and Libby German. Last week brought relief for families and for many around town after an arrest was made. Richard Allen of Delphi now facing charges of murder. But new court documents show Judge Benjamin Diener recused himself in the case, which the Indiana Supreme Court confirmed earlier this afternoon. In court filings, Judge Diener writes he was attempting to ignore the maelstrom of interest from the public, saying there was already content about his family on YouTube, including photos. Judge Diener writes the public's bloodlust for information before it exists is extremely dangerous. And when the public peddles misinformation with reckless abandon, we all are not safe. A spokesperson for the Indiana Supreme Court says they're in the process of appointing Allen County Judge Fran Gull as a special judge in the Delphi murder case in Diener's place. Gull has served as a judge in Allen County for more than 20 years, overseeing several significant cases, including Bob Leonard's trial after the Richmond Hill explosion. That explosion set deliberately as part of an insurance scam, killing 2 on Indy's south side and leading to the destruction of 30 homes 10 years ago, next Thursday.
The enormity of the case, the amount of destruction, the death, the descriptions that you hear, that it's like a war zone. So.
A judge doesn't have to give a specific reason for recusing themselves in the case. There are several reasons that would require a judge to step away, though, including personal bias or prejudice of a person or their attorney, if they have personal knowledge of disputed facts in the case, or having a close relationship to someone involved in the case. And while the future of the judge in Allen's criminal case now appears to be decided, information on what led to Allen's arrest is still under wraps. Those records are still sealed by the court. Court filings did reveal, however, that when the defendant appeared for his initial hearing, he was wearing protective gear. Judge Diener writes that was not to protect Allen from the court, but rather that protection was to protect the defendant from the public.
Just tonight, we learned that Richard Allen has been transferred to a state prison here in Indiana. The court says it's for safekeeping, saying that he's in imminent danger of being hurt or killed. Here's a look at what we also know tonight about the suspect in this case. Allen's initial bail was set at $20 million following his arrest. Several days later, the prosecutor said Allen is now being held with no bond. This case returns to court on November 22nd. That's when they'll hold a hearing to decide whether or not key documents in the case will remain under seal. And another development today, Kelsey German, Libby's sister, posted this. If you have a minute today, please sign this petition to keep the probable cause documents sealed. As we focus on the next steps in this investigation and the future court hearings, we're also looking back on how we've covered this story since February of 2017. Saturday night at 7, we'll air the Delphi Murders Arrest Special. This will feature a new interview with Indiana State Police. Again, that's Saturday night at 7 o'clock.
Moving now to developments in the case against Kegan Kline. The Miami County prosecutor is asking the court to dismiss 5 charges in the child pornography case against him. Kline's been in jail for more than 2 years, waiting to go on trial for 30 counts of child porn possession, exploitation, and obstruction of justice. Kline admitted to creating the fake Anthony Schatz profile online, which was one of the last to communicate with Libby German before her death. But to be clear, Kline has never been named a suspect in the Delphi murders.
And thank you to WTHR for allowing the use of that tonight. Well, welcome to everyone. Wednesday, December 4th. It's not very late. It's not very early. So we are here where we are. And God bless everyone for being here. Let me say hello to you before we go any further. It's good to see everyone. And we have a lot to cover. So God bless you all. And there were some interesting things in there, but we'll be talking about that tonight. Let's see who we got in here. All right. All the way back. So we got Kayla. Thank you, Kayla, for coming in early and putting up the support pathways. Everyone, please support the channel, especially through Cash App, which I've pinned down here at the top of the chat. Please send me a Cash App if you want to support the channel. Welcome into Woman Doing and Donnie Pitbull Kuntz, Marianne, Deputy Dog, Peaches81, Miss K, Tracy Fleetwood, Rebecca Ann, the lovely Rebecca Ann, 1965, Nature Loving Lady, Regina Grady Bolden, Digital, Crazy Girl 1203, Lisa, Amy. What's up, Amy, with the flowers? That up there. Bobby Smith, Say What? Welcome in. Eliana Davidson, Digital, Sweet Dude Shibby, EWTN, Phoenix. Thank you, Fiend, for the help. Grateful 7, Guitarist A67, Judy Hathaway, Missouri Memo of 9, Heavy Metal Rehab, and Jenny 33, Scalesman Justice, Royal Wee. All right. Asha Harry, welcome in. Icy Cat, Winter, Texas Lady, Mino Dino, Amy Mickey, Heather Brown, Nature Loving. Well, I already said that. Welcome, everyone. Welcome. Sheba B. Okay. I don't want to miss anyone, so please forgive me if I do. It's a new day. Welcome in. Yes, please hit the like also. Thank you for the reminder. It's a new day. Nancy Drew 101, Rick, Veronica, Niobe. Who else we got in here? Bella is in Wonderland. And we got Mary Martin, Free Ricky Bay, Darla, Dream Suburb. We got Spike Dog. What up, Spike Dog? And we got Malibu. All right. Bonnie. And we have who else in here? I'm thinking we're getting everyone. Okay. Joey Lowell. Thank you, Joey. Looking good, looking good. Okay. I think I've covered everyone so far. Marianne. We didn't want to miss you. V, welcome, V. Corner Piece Puzzles, welcome. And Swade Smith, welcome. Drive safely, Swade. Everyone looks good. What's up, David Gray? Okay. Lily Shaw, what's up, Lily? All right, it's a new day. Thanks for the $5 super sticker. Boom, starting us off. Right, okay. Deborah, welcome, Deborah. Welcome, Debbie Packer. All right, all you lovely people, welcome on in here. Welcome to the show. Good to see you. So, wow. Oh, you're from Utah. Well, you're my neighbor. Welcome from Utah. And welcome to Andre. Welcome, Andre. All right, Joni P, welcome. All right, and Don McKenzie, welcome. You guys are still coming in. All right, well, welcome everyone coming in. And I encourage all of you who are just watching, please go ahead and I encourage you to join the chat. Leave a comment down below in the chat. And if you're on the replay, leave a comment down below in the comment section. We would love to hear from you. We appreciate everyone here. And good discussion is always healthy for the soul. Okay, it's good for the soul. Mama Bear, welcome. Scalesman Justice, welcome. All right, so what we're doing tonight, I've called it Delphi Bloodlust. And be mindful that blood and lust together give us bloodlust. And And one thing that I'm extremely concerned about is the general level of blood and lust in central Indiana. We are all concerned about it. We're highly concerned about it. It's not just in central Indiana, though. It's all over. And we know that we're focusing specifically, though, on the Midwest and Indiana in particular, because we're highly concerned about the number of apparent hate crimes, the number of arsons, the number of suspicious murders, and deaths, and all of the like. And so we're highly concerned about that. And also the culture of fear that's been instilled in the community due to this, which we think is a direct result of the fear and intimidation tactics used by the criminal underworld in the area. And so that's why we come daily to speak on it. And we're trying our best. We're really trying our best to get a collaboration between a lot of great minds. And on a daily basis, I reach out to great minds and try to pull them on into the fold and try to bend their ear, if they will allow it, for good advice. And that's what's going on. So tonight I'd like to start by reading this for you. And I'm going to try to keep it together. Look, there's so much when it comes to presenting these slides that it's hard for me to do everything at once, which means handling the discussion in the chat and making sure I have my slides properly sequenced, keeping my train of thought together, and reading with some somewhat problematic vision. So here we go. This is from a news article that was written in November of 2022. It says, a northern Indiana judge has recused himself from the case of 2 slain teenage girls, an Indiana Supreme Court spokeswoman said Thursday. The Indiana Supreme Court is in the process of appointing Allen County Superior Judge Fran Gull as special judge in the case after Carroll Circuit Court Judge Benjamin Diener recused himself, spokeswoman Catherine Dolan said. A judge does not have to explain a reason for recusal, Dolan said in an email to the news media. Diener's recusal came on the same day he approved a request from Carroll County Sheriff Tobe Lesenby to transfer Richard Allen, the suspect in the 2017 killings, to the Indiana DOC for safety reasons. Okay, and here's where we're getting into the effery. Okay. So let's continue. In the order to transfer Allen, Diener wrote, this finding is not predicated on any acts or alleged acts of the defendant. Since arrest, rather, a toxic and harmful insistence on public information about defendant in this case. Okay, so let's read that again, because I truly do believe it's important to listen to every word when words matter. Okay, so again, this finding, in other words, the order to transfer Allen into the DOC custody, remember, which technically meant plausible deniability for placement into Westville. Okay. Hold on. I see I have to control a maniac in the chat. So just give me a moment, please, because maniacs in the chat come to disrupt us. And what we want to do is document them. And that's what I'm doing now. And then we move on. Okay. All right. Documenting, deleting, and moving on. Thank you. So what I am getting at is we know that Allen was handed to the DOC by Benjamin Diener, okay, specifically in order to cleanse his hands of Allen and cleanse the county's hands of Allen and put the responsibility or pass the buck onto the DOC when it comes to accountability for placing him into the abusive environment of Westville, where he would suffer torture, deterioration, threats, abuse, and ultimately a situation that coerced him into confessions and violations of his human rights and constitutional rights, which are appalling and probably will be discussed and addressed years on into the future. But we'll be getting to that. But keep in mind, when we're looking back at this in retrospect, we need to be paying attention to every word. So let's go back to every word. The finding, or this finding, in other words, transferring him into DOC, is not predicated on any acts or alleged acts of Allen, defendant, since arrest, but rather a toxic and harmful insistence on public information about defendant and the case. So this act of transferring him into DOC, meaning Westville, ultimately, the onus was put on the public for our own curiosity and desire to have information which should be public information and transparency from the state in this case. So you see how that works. It's awfully I don't know. It's awfully disappointing, disgusting, interesting, all of those things, that the sleight of hand, I guess, is what I'm getting at, that we're taking an individual who has done nothing on his own to cause such acts, and we're going to use the excuse or blame the public in their own curiosity or desire to have information about a case that is at the center of worldwide attention, a case that people feel passionately about. And we're going to blame them for that interest and passion that the own locals have created, and the perpetrators, in terms of the appeal or the magnet, I would say the magnetic appeal that the Bridge Guy video had in this case, okay? Drawing such intense scrutiny and attention to this case. So it's just extremely interesting to me that what Diener did at the very moment that he recused himself, he did a number of sleight of hand. It's a magic trick, basically, to say, I'm stepping down, I'm recusing myself, I'm getting out of here, while I remand him into the custody of DOC, where he will go into Westville and be abused and tortured for more than a year, and confessions will be coerced out of him as a result of the intent to force him into a plea deal while he's guarded by Odinist guards and this sort of things. Very difficult situation, but I thought that particular sentence was awfully gaslighting and infuriating, that we're blaming the public and the desire for information about the case as to the reason why he's being transferred, when we know that the actual threat to Allen are the local criminal element who may have a vested interest in causing harm to Mr. Allen, or the inmates themselves who may have a reason to perform some sort of assault on Mr. Allen as a result of the accusations. So all of the threat to Mr. Allen was absolutely coming from the criminal element in Indiana and in the incarcerated environment or in the prison, not coming from any of the public out here. But Diener, nevertheless, found that there needed to be a transfer of Allen into a dangerous environment like Westville. Just think about it. I guess what I'm trying to get across here, think about it. Allen was placed in a more dangerous environment, in a less healthy environment, in a more abusive, a more dangerous environment. And that is Westville, with this very request. Okay. This very order to transfer placed him into a more dangerous situation, a less healthy situation. But the excuse is that he's being placed into this more dangerous place for his own safekeeping because the public wants information. It's just completely infuriating. So I hope you get it. I hope you get it, what I'm getting at. Okay, let's continue. Diener said the court found Allen to be in imminent danger of seriously bodily injury or death, or representing of a substantial threat to the safety of others. Okay? He also addressed what he learned, or what he termed, public bloodlust for information in the case, calling it dangerous and saying all public servants working on the case do not feel safe or protected. The order went on to state the public's desire to learn about the case and access court records was inherently disruptive to court operations. Allen is being held on a $20 million bond, online court records show. Allen, 50, was arrested Friday on 2 murder counts in the killings of Liberty German, 14, and Abigail Williams, 13, in a case that has haunted Delphi. The deaths were ruled a double homicide, but police have never disclosed how they died or described what evidence they gathered. A relative had dropped them off at a hiking trail near the Monon High Bridge just outside their hometown of Delphi, about 60 miles northwest of Indianapolis. Their bodies were found the next day, February 14, 2017, in a rugged, heavily wooded area near the trail. It's not entirely accurate, by the way. Diener entered a not guilty plea for Allen at his initial hearing on Friday. Okay, so you understand what I'm saying about this is an infuriating document, or the news article itself is relaying this document, which is infuriating because the blame is being put on the public's desire for information and court records, with the insinuation that the imminent danger of serious bodily injury or death related to the necessity to transfer Allen into a more dangerous environment was coming from the public. So just absolutely infuriating. But let me continue, please. All right, so right here, what we're going to do, let me remove this so we can actually see this. All right. Okay. This is the actual order from Diener, and I'd like to read it for you because I know some of you are aware of this, but this is for those of you who are not. Okay, we are aware that many new people have come into this community and have interest in the Delphi murders case and the specifics of the case against Richard Allen. So I'd like to read this for you who have not yet reviewed it for yourselves. It says, order on November 2nd, 2022, Tobe H. Lesenby, Sheriff of Carroll County, filed a request by the Sheriff of Carroll County to transfer inmate from Carroll County Jail to the custody of the Indiana Department of Corrections for safekeeping. The court, being duly advised, finds that defendant is an inmate awaiting trial and is in imminent danger of serious bodily injury or death, or represents a substantial threat to the safety of others. This finding is not predicated on any acts or alleged acts of the defendant since arrest, rather a toxic and harmful insistence on public information about the defendant and this case. In general, this court has 30 days to rule on any motion that is filed by a party in any case. See Indiana Trial Rule 53(1)A. And let me just stop there. And you guys know that this court has regularly violated that Indiana Trial Rule 53(1)A. And if you're not aware of that, you should make yourself aware. Okay. Yet, concurrent to the actual case naturally occurring, this judicial officer keeps getting direct requests from non-parties for public information in quotations, claiming that this officer has 7 days or 1 day when hand-delivered to respond to the request or face litigation. Okay. And in the red box, while this officer is responsible for the entirety of the circuit court docket, it attempts to ignore the maelstrom of interest from the public. It is known that YouTube already hosts content regarding family members of this judicial officer, including photos. The public's bloodlust for information before it exists is extremely dangerous. All public servants administering this action do not feel safe and are not protected. The Carroll County Sheriff has limited resources to conduct its base operations, let alone any duties mandated by our Supreme Court. All defendants in all actions are presumed innocent. All public information will be available the second it exists. None of the family members of public servants are part of this action. All of the public servants are simply people doing their jobs. Most of the public servants are woefully underpaid. Most of the public interest consists of people attempting to raise their status or profit financially. When the public peddles misinformation with reckless abandon, we all are not safe. As far as the public's desire to learn about access to court records, that educational effort cannot be by this officer educating each individual ad hoc whenever they choose to seek, quote, public information, close quotation. These inquiries are inherently disruptive to the operations of the court, as they are wholly outside the operations of the court. As a branch of the Supreme Court, any request for public information about this action should be directed to whomever is the public information coordinator for the courts in general. If there is not such a position, our state may need one. Defendant indicated at the initial hearing an intention to hire private counsel. Defendant is reminded that he must retain counsel within 20 days of the initial hearing because there are deadlines for filing motions and raising defenses. And if those deadlines are missed, the legal issues and defenses that could have been raised will be waived or given up. If defendant is unable to retain counsel of his choosing due to financial indigency, defendant is reminded that he is entitled to court-appointed counsel and defendant will be examined upon request. The court notes for the public that when defendant appeared for the initial hearing, he was clad in protective gear. That protection was not to protect defendant from the court. That protection was to protect defendant from the public. Until a finding of guilt or a judgment of conviction occurs, in any case, judgment must be reserved and the presumption of innocence must be respected and preserved. Accordingly, pursuant to Indiana Code 3533.11.1, the court orders the Sheriff of Carroll County to transfer the defendant to a facility of the Department of Correction designated by the Commissioner of the Department as suitable for the confinement of defendant and provided that space available. So ordered this 3rd day of November 2020. Okay. All right. Now, there's more. There's more. Let's see. Now, this same day he recused himself, it steps down. Now I'm going to read order acknowledging public hearing. A public hearing will be conducted pursuant to Indiana Code 514355 and Indiana Rules of Court, Rules on Access to Court Records, Rule 6, November 22nd, 2022 at 9 a.m. in the Carroll Circuit Court. Parties or members of the general public will be permitted to testify and submit written briefs subject to reasonable time constraints imposed by the court. A decision to seal all or part of a public record must be based on findings of fact and conclusions of law, showing that the remedial benefits to be gained by effectuating the public policy of the state declared in Section 1 of this chapter are outweighed by proof of a preponderance of the evidence by the person seeking the sealing of the record. That 1, a public interest will be secured by the sealing of the record. 2, dissemination of the information contained in the record will create a serious and imminent danger to the public interest. 3, any prejudicial effect created by dissemination of the information cannot be avoided by any reasonable method other than the sealing of the record. 4, there is a substantial probability that sealing the record will be effective in protecting the public interest against a perceived danger. And 5, it is reasonably necessary for the record to remain sealed for a period of time. Sealed records shall be unsealed at the earliest possible time after the circumstances necessitating the sealing of the records no longer exist. So ordered the 2nd day of November, 2022. Okay. Now, remember in the news report we just listened to at the introduction, coincident with these filings was the family urging the public to sign a petition for sealing. Especially in that regard, I mean, Becky Patty and Kelsey German urged the public to sign a petition that was spread around, independent of the court, to keep the probable cause affidavit under seal. Okay, now here's where we get into some very, very strange oddities. Keep in mind that when this probable cause affidavit was released initially, it was highly redacted. Okay, it was highly redacted. How many of you are aware of that? Sorry about that. Okay, I'd just like to know how many of you are aware of the highly redacted nature of that. Okay. So there's some things about it, because let me see if I can I should have pulled this up on screen for you guys. When this PCA was released initially, there are two things. Highly redacted, missing signature page. Okay. So let me take this down for a moment, just a moment. And I truly am sorry for the time that it takes to do this. I'd love for us to go more quickly and for this to be brief, but for everyone's benefit who has not already heard this stuff, I think it's necessary to be thorough. Some people may be hearing this for the very first time. So let's take a very, very quick look at the probable cause affidavit in its redacted form, okay? Because I want to display for you the oddities of why this would be not only sealed, but this redacted document was sealed and, oddly enough, was missing the signature page. So we'll get into it, okay? I, the undersigned affiant, submit the following information pursuant to IC 353372 as a sworn affidavit setting forth the facts and circumstances known to law enforcement of Carroll County as a basis for probable cause to arrest without a warrant or to establish probable cause for the issuance of an arrest warrant for the above named defendant. That the facts and circumstances described below would be sufficient basis for a person of reasonable caution and prudence to believe that the accused has committed or attempted to commit the offense described as, and that if attested without a warrant, such would be authorized under IC 353311. That the hearsay statements of witnesses contained herein are considered reliable and credible due to the witness's personal knowledge and are corroborated by the totality of the circumstances. Okay. Now, I'm going to quickly go through this, but please keep in mind, okay, I do not believe that these are facts that are set out accurately in this probable cause affidavit. I think it is full of errors. It is full of omissions, okay? So let's continue. Then on February 14, 2017, victim 1 and 2 were found deceased in the woods approximately 0.2 miles northeast of the High Bridge in Carroll County. Their bodies were located on the north side of Deer Creek. Okay, I'm okay with that. Fine with that. That is a statement of fact. At the time, the Monon High Bridge Trail was approximately 1 mile, was a 1 mile gravel trail terminating at the Monon High Bridge. The Monon High Bridge is an abandoned railroad trestle approximately 0.25 miles long, spanning the Deer Creek and Deer Creek Valley on the southeast end of the trail, approximately 0.7 miles northwest on the trail from the northwestern edge of the Monon High Bridge is a Freedom Bridge, which is a pedestrian bridge spanning State Road 25. Approximately 300 feet west of Freedom Bridge was a former railroad overpass over Old State 25, also known as County Road 300 North. The trail terminates just west of the former railroad overpass. The majority of the trail is in a wooded area with a steep embankment on the south side of the trail. The entirety of the trail and the location of the girls' bodies were and are located in Carroll County, Indiana. Through interviews, reviews of electronic records, and review of the video at the Harvest Store, investigators believe victim 1 and victim 2 were dropped off across from the Mears Farm at 1:49 p.m. on February 13th, 2017 by redacted. The Mears Farm is located on the north side of County Road 300 North, near an entrance to the trails. A video from victim 2's phone shows that at 2:13 p.m., victim 1 and victim 2 encountered a male subject on the southeast portion of the Monon High Bridge. The male ordered the girls down the hill. No witnesses saw them after this. No outgoing communications were found on victim 2's phone after this time. Their bodies were discovered on February 14, 2017. Okay, there's one problem I have with that, which is no, That male did not necessarily order the girls' guys down the hill. It's not definitive. It's questionable. It's something that appears to be extremely problematic factually. We are more likely or more inclined to believe that someone behind the girls or just coming up on the girls at a near distance whispered to them down the hill. It's very difficult for those who were in attendance at the trial to conceive that the individual in the far distance, whose mouth could not be seen moving, said guys down the hill, and that it was loud enough to travel that far of a distance to make it to the microphone of the phone. So it's very unlikely that that subject that was filmed briefly at a great distance was the individual male who said to the girls down the hill. So we'll continue with that. Other than that, I believe there's some validity to these alleged facts in here. The video recovered from victim 2's phone shows victim 1 walking. That's another thing. The definitiveness at which that victim number 1 can be identified is at question here. So we'll continue. Southeast on the Mona High Bridge, while a male subject wearing a dark jacket and jeans walks behind her. As the male subject approaches victim 1 and victim 2, one of the victims mentions gun. That's again speculative. After review, we've learned that it's very unlikely that that victim mentioned gun. Okay, it seems to be somewhat of an assumption or a projection and possibly a fabrication. Near the end of the video, a male is seen and heard telling the girls, guys down the hill. I do agree with that sentence, okay? Pay very close attention to how that sentence is phrased. Near the end of the video, a male is seen and heard telling the girls, guys down the hill. I do agree with that. Okay. I don't necessarily believe that it's the same male that is filmed. Okay. The girls then begin to proceed down the hill and the video ends. Well, that's another thing. There's really no clear indication that the girls proceed down the hill. It's difficulty. Okay, it's a lot of difficulty. When all of this hits the public airwaves, you will all understand my statements at this point in time. When we are able to see it and examine it very closely, you'll understand my statements that I'm making at this time, that it's very, all of this is very tenuous when it comes to this 43-second video. Okay. A still photograph taken from the video and the guys down the hill audio was subsequently released to the public to assist investigators in identifying the male. Yes, and what's omitted from that particular sentence is that an enhanced still photograph from the video and an enhanced audio clip was released to the public. Okay, and by enhanced, I mean interpolated, tampered with, manufactured, AI assisted, and also realize that subsequently a video segment was also released, which was also enhanced, manipulated, animated, interpolated, etc. Victim 1 and victim 2's deaths were ruled as homicides. Well, that's absolutely certain, and it's great. Okay, the clothes were found in Deer Creek belonging to victim 1 and 2. True. South of where their bodies were located. True. There was also a .40 caliber unspent round less than 2 feet away from victim 2's body, allegedly. Between victim 1 and 2's bodies, the round was unspent and had extraction marks on it. Well, that's still, it's questionable because the chain of custody, the collection of the round, and the lacking of documentation of that entire process. Interviews were conducted with 3 juveniles, redacted and redacted. They advised they were on the Monon High Bridge Trail, and here we're coming with witnesses. Okay, these witnesses who are going to be utilized. And please be aware, there were other witnesses. Okay, so that's something that everyone continues to try to ignore. There were other witnesses who were not utilized. Actually, just as many witnesses were ignored as those who were utilized. So There was some sort of a nitpicking of the utilization of witnesses. They advised they were on the Monon High Bridge Trail on February 13, 2017. They advised they were walking on the trail toward Freedom Bridge to go home when they encountered a male walking from Freedom Bridge toward the Monon High Bridge. Redacted described the male as kind of creepy. She advised he was wearing light blue jeans and like a really light blue jacket. No, actually, she said tan. His hair was gray, maybe a little brown, and he did not really show his face. She advised the jacket was a duck canvas type jacket. Redacted advised she said hi to the male, but he just glared at them. She recalled him being in all black. Yes, remember, and that all black was from head to toe. Okay, head to toe, blacked out. She described him as not very tall with a bigger build. No, she actually said muscular with a bigger build. That she said muscular and tall, approximately 5'10". Okay, but notice how the words are twisted here too. She said not bigger than 5'10". Well, yes, because saying 5'10" means probably not 5'11" or 5'12", but she said approximately 5'10", judging from her height. Redacted advised he was wearing a black hoodie, black jeans, black boots. You understand? All black again. She stated he had his hands in his pockets. Redacted showed investigators photographs she took on the phone while she was on the trail that day. The photographs included a photo of the High Bridge taken at 12:43, another one taken at 1:26 on the bench east of Freedom Bridge. Redacted advised that after she took the photo of the bench, they started walking back towards Freedom Bridge. She advised that when they encountered the man who matched the description of the photograph taken from victim two's video. Redacted described the man she encountered on the trails wearing a blue or black windbreaker jacket. She advised the jacket had a collar and had his hood up from clothing underneath the jacket. She advised he was wearing baggy jeans and taller than her. She advised her head came up to approximately his shoulder. Yes, which means he was still approximately 5'10" and muscular. She advised she said hi to the man and that he said nothing back. She stated he was walking with a purpose, like he knew where he was going. She stated he had his hands in his pockets and kept his head down. She advised she did not get a good look at his face, but believed him to be a white male. The girls advised after encountering the male, they continued their walk across Freedom Bridge and the old railroad bridge over Old State 25. Okay, so what we're encountering here are we're starting to encounter the problems with the witness statements in matching the description of Richard Allen. So we are getting a description that's pretty consistent of an individual, but this individual appears to be closer to the range of 5'10" and closer to the age range of 20s and closer to a muscular build rather than a short, stout man. We're dealing with a taller, muscular man, and rather than a man in his 40s or 50s, they are witnessing someone in his 20s, possibly 30s, and rather than someone dressed in all blue or blue jeans, blue jacket, we're dealing with someone dressed in all black. So really big problems here with the witness description, but we'll continue. Investigators spoke with Redacted, who advised she was on the trails on February 13, 2017. Video from the Harvest Store captured Redacted's video traveling eastbound at 1:46 p.m. toward the entrance across from Mears Farm. Redacted advised she saw 4 juvenile females walking on the bridge over Old State Road 25 as she was driving underneath on her way to park. Redacted advised there were no other cars parked across from Mears Farm when she parked. She advised she walked to the Monon High Bridge and observed a male matching the one from victim two's video. She described the male she saw as white male wearing blue jeans and blue jean jacket. She advised he was standing on the first platform of the Monon High Bridge, approximately 50 feet from her. She advised she turned around at the bridge and continued her walk. She advised approximately halfway between the bridge and parking area across from Mears, she passed 2 girls walking from toward Monon High Bridge. Remember, she advised she believed the girls were victims 1 and 2, so that's another problem there. Video from the Harvest Store shows at 1:49 p.m. a white car matching Redacted vehicle traveling away from the entrance across from Mears Farm. Redacted advised she finished her walk and saw no other adults other than the male on the bridge. Her vehicle is seen on Harvest Store video at 2:14 p.m. leaving westbound from the trails. Redacted advised she was leaving And she noted a vehicle was parked in an odd manner at the Child Protective Services building. She said it was not odd for vehicles to be parked there, but she noticed it was odd because of the manner it was parked, backed in near the building. Now, remember, this is where an omission is made. And what omission is made at this point is the specific description she gave of that vehicle, which was something resembling a 1965 Mercury Comet, which her father owned. So something similar to that with angular shapes, which she later then sketched, okay, and reflected that angularity in the shape. Definitely not a modern Ford Focus, but we'll continue. Investigators received a tip from Redacted in which he stated he was on his way to Delphi on State Road 25 around 2:10, February 13, 2017. He observed a purple PT Cruiser or a small SUV type vehicle parked on the south side of the old CPS building. He stated it appeared as though it was backed in as to conceal the license plate of the video. Yeah, but you have to understand. See, I would highly recommend any of you visit the area. Do that drive on Old State or State Road 25 yourself, and you'll see that it's very unlikely that you would pick up that much detail in passing by where that building used to be. Kind of questionable. It gives a pretty clear understanding of why he would say something like a purple PT Cruiser, small SUV. He just had a glancing shot at it, but I don't know why he would assume that the agenda or the motivation to back into the building was to conceal the license plate. Both drew diagrams of where they saw a vehicle parked, and their diagrams generally matched as to the area, which means near the building, okay? Redacted advised he remembered seeing a smaller dark-colored car parked at the old CPS building. He described it as possibly being a smart car. Redacted's vehicle seen is leaving at 2:28 on the Harvestor video. Investigators spoke with Redacted, who stated she was traveling east on 300 North February 13th and observed a male subject walking west on the north side of 300 North, away from the Monon High Bridge. Redacted advised that the male was wearing a blue-colored jacket and blue jeans and was muddy and bloody. Now, that's where we have a huge problem. Huge, major, monumental problem. And all of you know that. She actually advised she saw a male wearing a tan-colored sweaty or hoodie and was muddy. So how does that tan-colored hoodie that is muddy, or a man wearing a tan-colored hoodie who appeared to be muddy from the knees down, how does that turn into a man wearing a blue jacket who is muddy and bloody? She further stated it appeared he had gotten into a fight, slaughtered a hog. Investigators were able to determine from watching video from the Harvestor that Redacted was traveling north, on CR 300 North, approximately 357. Through interviews, electronic data, photograph, and video from Harvestor, investigators determined that there were other people on the trail that day after 2:13. Oh, yes, indeed, there were. Those people were interviewed, and none of those individuals encountered the male subject referenced above. Further, none of those individuals witnessed victim 1 and 2. So are you picking up what I'm putting down here? That only one witness witnessed who she believed could have been victims 1 and 2. No one else, whosoever, no one else saw victims 1 and 2. Even our witness, we don't know if she saw 1 and 2. Several of the witnesses were not utilized in this document. The witnesses who were utilized seem to be describing an entirely different individual, at least when it comes to concerning Richard Allen. They appear to be describing a tall, young man dressed in all black from the head down. I believe those witnesses saw a tall young man dressed in all black from the head down. I believe that if they had seen a very short man with a beer belly dressed in blue, they would have said so. I believe that if they had absolutely witnessed Abby and Libby, they would have said so. Just a moment. Okay. Now we're going to get to an infuriating point here, and I'm going to try to rush through this because the point was not to read this to you, to be honest. I'm just rushing through it. Now, this is interesting here because there's another spin. Okay, there's another spin here. Investigators reviewing prior tips encountered a tip narrative from an officer who interviewed Richard Allen in 2017. Okay, that's not necessarily accurate, is it? Let's make it accurate. Miss Kathy Shank miraculously discovered in a desk drawer a tip narrative sheet on paper, which had a mark in green indicating cleared, and she took it upon herself to become concerned about that cleared tip that was found in that desk drawer. And just coincidentally, Mr. Liggett was around that day, and she figured she would take it upon herself to express her concern about this cleared tip to Mr. Liggett, and went and walked it over to him, which then started the ball rolling, allegedly, according to this story. Wherein this following narrative comes into play. Okay, so keep in mind that Miss Shank just happens to be a personal family friend to the Patty family, and also a great fan and supporter politically of Tony Liggett. And we have all that documentation to prove to you, just in case you're curious about that. Now, keep in mind also, before I go any further, because this infuriates me, keep in mind that there's no record of this tip that I'm about to read to you. There's no written record anymore, which at a bare minimum one would expect. And miraculously, there's no recorded record, even though Mr. Doolin's habit was to record his encounters of this sort. So this interaction and this tip should have been recorded, would have been recorded, and may have been recorded, to be honest with you. But at this point in time, the allegation is that recording cannot be found, therefore must not exist, or has been lost, and that the handwritten notes on the back of a tip sheet also have not been found, which means must have been destroyed. So everything you're about to hear, we have to take their word for it, because all of the records don't exist. Anyhow, that narrative stated, the one that doesn't exist and we cannot confirm, and we have to take the word for it, is as follows. Mr. Allen was on the trail between 1330 and 1530. But again, No record exists, so we have to take the word for it. He parked at the old Farm Bureau building and walked to the new Freedom Bridge. While at the Freedom Bridge, he saw 3 females. He noted one was taller and had brown or black hair. He did not remember description, nor did he speak with them. He walked from Freedom Bridge to High Bridge. He did not see anybody, although he stated he was watching a stock ticker on his phone as he walked. He stated they were vehicles parked at High Bridge trailhead, however, did not pay attention to them. He did not take any photos or video. Odd. That's more than one. Have you noticed that? He stated there were vehicles. Did he state there were vehicles? Were there multiple vehicles? Whose vehicles were there? Okay, then there's information about the cell phone. Investigators believe Mr. Allen, and look, when every time this document says investigators, what it means is I. Okay, Mr. Liggett is authoring this, and he basically means he. And throw Mr. Holman in as well, as they're one and the same, two sides of a coin. We, Liggett and Holman, believe Mr. Allen was referring to the former Child Protective Services building, as there was not a Farm Bureau building in the area, nor had there been. Investigators believe the females he saw included redacted and redacted due to the time they were leaving the trail, the time he reported getting to the trail, and the descriptions the 3 females gave. No, but I don't agree with that. I believe that he saw exactly what he believes he saw, 3 females, not 4. So if he saw 3, I'd like a description from Mr. Allen. Who were those 3 females? Can you please describe those 3 females, or can you personally identify them in a lineup? Who were the 3 females you saw? Were they the 3 who have become our witnesses? Investigators discovered Richard Allen owned 2 vehicles in 2017, a black Ford Focus 2016 and a 2006 gray Ford 500. Investigators observed a vehicle that resembled Allen's Ford Focus on the Hoosier Harbor Store video at 1:27 p.m. traveling westbound on County Road 300 North in front of the Hoosier Harbor Store, which coincided with his statement that he arrived around 1:30 at the trails. Investigators note witnesses described the vehicle parked at former CPS building as a PT Cruiser, small SUV, or smart car. Investigators believe those descriptions are similar in nature to a 2016 Ford Focus. Why did he omit, again, the 1965 Mercury Comet description? To be accurate, it should have said, witnesses described the vehicle as a PT Cruiser, small SUV, 1965 Mercury Comet, or smart car. Anyhow, those magically all become one thing, and we omit the 1965 vintage vehicle. To October 13, 2022, Richard Allen was interviewed again by investigators. He advised he was on the trails. February 13, 2017, he stated he saw juvenile girls on the trails east of Freedom Bridge and that he went on Timon and High Bridge. Richard Allen further stated he went out on Timon and High Bridge to watch the fish. Later in his statement, he said he walked out to the first platform on the bridge. He stated he then walked back, sat on a bench on the trail, and left. He stated he parked his car on the side of an old building. He told investigators that he was wearing blue jeans and a blue or black Carhartt jacket with hood. He advised, let me add that when his clothing was gathered as evidence by law enforcement and forensically tested, not one piece of his clothing exhibited signs of any DNA, blood splatter, DNA from the victims, blood splatter from the victims, and no sign of the victims whatsoever at all, zero zilch on any of his clothing that he believes he was wearing that day. He told investigators he owns firearms and they are at his home. Richard Allen's wife, Kathy Allen, also spoke to investigators. She confirmed that Richard did have guns and knives at the residence. She also stated that Richard Allen still owns a blue Carhartt jacket. Yes, and keep in mind that blue Carhartt jacket means nothing. It was tested. It was cleared. No DNA, no blood, His vehicle, no DNA, no blood. His other clothing, no DNA, no blood. His gun, no DNA, no blood. All of his knives, no DNA, no blood. Okay. Investigators executed a search warrant on October 13. Officers located jackets, boots, knives, firearms, including a Sig Sauer model P226 40 caliber with serial number U625627. And guess what? Neither one of those items tested positive for any DNA of the victims, any blood from the victims. Zero, zilch, zilch, nada. Between October 14 and October 19, the ISP lab performed an analysis of the Sig Sauer model P226. The laboratory performed a physical exam and classification of the firearm, function test, barrel and overall length measurement, test firing, ammunition component characterization, microscopic comparison, and knee bend. The laboratory, oddly enough, determined that that unspit round found within 2 feet of the victim 2's body had been cycled through Allen's gun because they somehow magically matched it to a fired round from his gun and had the difficulty excluding other guns extracting that round. So junk science is the way we refer to it. Remarks from the laboratory: an identification opinion is reached within the evidence when the evidence exhibits an agreement of class characteristics, blah, 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 blah. I'm not reading through all that. Okay. Investigators ran the firearm and found that the firearm was purchased by Richard Allen in 2001. Richard Allen voluntarily came to the ISP post on October 26, 2022. He spoke with investigators and stated he never allowed anyone to use or borrow the Sig Sauer model P226 firearm. This is why you never, ever do that. He should have asked for his attorney. This was all an entrapment, I believe. When asked about the unspit bullet, he did not have an explanation of why the bullet was found between the bodies of victim 1 and victim 2. And he wouldn't if he was innocent. If he was not out there in that location with his firearm, he wouldn't have an explanation. He'd be completely dumbfounded as to why his round was found there. He admitted that he was on the trail, but denied knowing victim 1 or 2 and denied any involvement in their murders. Carroll County Sheriff's Department Detective Redacted has been part of the investigation since it started in 2017. I don't know why he redacted his own name. Isn't that funny? Isn't that funny? He has had an opportunity to review and examine evidence gathered in this investigation. Detective Redacted, along with other investigators, meaning Holman, believe the evidence gathered shows that Richard Allen is the male subject seen on the video from victim 2's phone. That's a strong belief. Further, that the victims were forced down the hill by Richard Allen. That's a strong belief, and led to the location where they were murdered. Through the statements and photographs of the juvenile victims and the statement of Richard Allen, redacted, and there's time frames. I'm going to skip all of this. Investigators believe the male observed by Redacted and the Redacted is the same male depicted in the video from victim 2's phone due to descriptions of the male by 4 females matching the male in the video. Yes, I'll give them that. In that paragraph, yes, the description of the 4 males, of the 4 females does match who I believe would be the male captured in the victim's video, Bridge Guy. But that description is a taller, muscular, younger individual. Do you understand what I'm putting across here? Okay. The victim described, the male described by the 4 witnesses, the 4 female witnesses, does appear to match the male captured in the video of the victim's phone, which we call Bridge Guy video. But that male appears to be in his 20s, 5'10" or taller, and muscular. So a young or youthful, tall, muscular man, not a short, squat, pudgy, or beer gut, tiny guy. So I do believe the 4 witnesses are describing Bridge Guy, also someone in all black, but I don't believe they're describing Richard Allen, who's a tiny man. Anyway, I'll continue. I'm sorry. Investigators believe Richard Allen was the male seen by witnesses and the male in the video. Richard Allen told investigators he was on the trail from 1:30 to 3:30. Remember, that's only according to the mysterious tip narrative that there's no record for. Okay. Video from Harvest Store shows a vehicle that matches the description of Richard Allen's car passing at 1:27 toward the former CPS building. The clothing he told investigators he was wearing matched the clothing of the male in victim two's video. No, it doesn't. No, it doesn't. It doesn't. Remember, that video has been interpolated, manipulated, tampered with, and edited to an extreme. And like I said, when we get our hands on the original, unedited, untampered, unfiltered, uninterpolated video, we'll be able to much more clearly understand what is seen and what is not seen and what matches and what doesn't match. A male matching Allen's descriptions was not seen on the trail after 2:13 p.m. Investigators identified other individuals on the trails or County Road 300 North between 2:30 and 4:11. You don't say who were the individuals on the trails or County Road 300 North between 2:30 and 4:11, because I think the world needs to know that. None of those individuals saw a male subject matching the description of Richard Allen on the trail. Well, but were any of those individuals involved in murdering these girls? Are we talking about the individuals in the geofencing among this group of people? Did any of the individuals in the geofencing see the girls, kill the girls, move the girls' bodies, take the girls? Investigators believe Allen was not seen on the trail after 2:30 p.m. because he was in the woods with victim 1 and 2. That's a strong belief. Again, strong belief. How do you know that none of those other individuals who were there, physically there, and actually are confirmed by infallible digital footprints to have been there at that very time, in that very place, between 2:30 and 4:11 p.m.? Keep in mind, between 2:30 and 4:11, what time did that phone stop moving? 2:32. What time is this alleged story over? 4 p.m. So between 2:32 and 4 p.m., let's review this statement. Investigators identified other individuals on the trails or County Road 300 North between 2:30 and 4:11. Wow, that just bookends the 2:32 to 4 p.m. time perfectly, doesn't it? So let's see. Investigators have already identified other individuals between 2:30 and 4:11 who were there. Investigators have geofencing evidence which concretely, forensically, and digitally establishes that they were there at that time in that window. But none of those individuals saw a male matching the description of Richard Allen. So that means it's only him, and he must be in the woods. What do Collier, Herrera, Mata, and the Browns have to say about that? What do Cheyenne, Shelby, other Shelby, Tara, Kelsey, Daniel, for starters? What do they all have to say about where they were, when they were, and who was where and who was when? Let me continue. I'm going to skip some. I'll start right here. Richard Allen stated that he had not been on that property where the unspent round was found, and that he did not know the property owner, and that he had no explanation as to why a round cycled through his firearm would be at that location. Well, I do believe he said that. He may have been telling the truth. Further, he stated he never allowed anyone to use or borrow the 6 Sauer Model P226. Investigators believe that after the victims were murdered, Rick Allen returned to his vehicle by walking down CR 300 North. Investigators believe he was seen by Carbaugh walking back to his vehicle on 300 North with his clothes that were muddy and bloody. No, because suddenly, think about this. Suddenly, you want us to believe that we had 4 girls who are seeing someone more or less in all black. We have Carbaugh who sees someone in a tan hoodie or sweater and is muddy. And you want us to believe that someone in a tan hoodie who has some mud below the knees, which magically turned into blood, you want us to believe that the tan with a little mud is also all black. Those two descriptions are very opposite. If someone would have said all black and someone would have said dark blue, you can see that that's a much more likely match. But it's a huge leap to say tan and all black. Again, tan and all black from head to toe. Big difference. Again, note this. Allen, man in tan, bridge guy, no one is seen on that Harvest Store video walking on by. Had his clothes been muddy and bloody, you would expect that blood would have been carried into the vehicle. He would have entered his vehicle bloodied, which is another thing. It's not logical. It's redacted, but I'm going to throw it on in here. Holman and Liggett believe the statements made by the witnesses because the statements corroborate the timeline of the death of the 2 victims. Oh, you know, the timeline of the death of the 2 victims. You mean the timeline that is as wide open as a winter weekend, you know, in I don't know, Lake Tahoe? So you got a huge window for possible times of death. We don't have accurate times of death. We don't know when those girls were unalived. But investigators nevertheless believe, and by that I mean Holman and Liggett, believe the statements made by these witnesses, who are all describing someone else, corroborate the 48 hours window of time of death. Okay. Sorry. So that's basically it. Okay, that's basically, I'm going to skip the closing sentences. But here's where, the reason I read that to you, here's where it gets odd. Because remember, we're talking about Diener recusing himself. Okay, we're talking about Diener. Like, you understand what we just read, right? What we just read makes no sense. It's illogical. It's stitched together with omissions. So Diener, in one fell swoop, he washes the county's hands of Richard Allen by remanding him into the custody of DOC to go and be tortured. And then he signs this questionable PCA. But not only does he sign it, does he sign it? Because remember, when this was originally released, and even to this day, but when it was originally released, there was a missing page. And this is the signature page. This is the signature page. This is the missing page, page 8. We call it page 8 because the redacted PCA was 7 pages. It was released, and we got page 1 of 8, 2 of 8, 3 of 8, 4 of 8, 5 of 8, 6 of 8, 7 of 8. And everyone wondered, where's page 8 of 8? So we raised hell about it. And because of the raising of the hell, this was released. Okay? Do you see a signature? Now, so the sequence of events we're supposed to believe is that items are sealed. Diener washes his hands of Richard Allen, sending him into DOC, where he can then be assigned to Westville and tortured and abused. He signs this PCA allegedly, but there's no signature. And then he recuses himself, blaming the public. Remember what I was saying when I was reading, okay? That this man, as the excuse to send Richard Allen into DOC, i.e. Westville, he cites the public bloodlust or the maelstrom of interest. Pay attention to the language. Request for public information. He cites public interest and YouTube. He cites fear of all public servants. He cites the public servants being woefully underpaid. Well, I would beg to differ. Do you really think that the attorneys or judges of Carroll County, do you believe that attorneys and judges are underpaid? I mean, dude, throwing in the underpaid was a gut punch to all of us out here who literally struggle to pay rent every month. Okay, we literally struggle to pay rent every month. But you, Mr. Judge, are underpaid. The attorneys are underpaid. The judges are underpaid. I don't think so. I don't think it's the public bloodlust that was a danger to Mr. Allen. I don't think it's the maelstrom of interest for publicly available court documents that are the problem. I don't think it's the YouTubers who were a threat to the, again, what did he cite? He said, imminent danger of seriously bodily injury or death. Do you really think the YouTubers and the public interest in court documents was of imminent danger of seriously bodily injury or death to Mr. Allen? And not only that, after pulling all of these questionable moves, you wash your hands of it and recuse yourself. Did you ever sign this page? You know you shouldn't have because it was terrible. So did you ever, or did you refuse to sign this page and step down? If you did sign the page, why is it not signed? Again, let's read the red boxes because I think it's worth driving this point home. While this officer is responsible for the entirety of circuit court docket, it attempts to ignore the maelstrom of interest from the public. It is known that YouTube already hosts content regarding family members of this judicial officer, including photos. Okay, guess what, buddy? Photos of my family are on the internet on YouTube because of the insane fucking culture of hate and the domestic terrorist of your state. So join the club, buddy. You're the actual presiding judge. I'm just somebody sitting in his living room YouTubing. Okay. My family's been posted on YouTube. But you're whining about your family. Okay. The public's bloodlust for information before it exists is extremely dangerous. How so? How so? I think there's bloodlust in Carroll County, but I don't think it's the public out here wanting information. I think it's those who are lighting on fire all the homes in the central part of the state. I think it's all of the mysterious deaths that keep happening, like Mr. Ferenczi, for instance. And then the court not holding anyone accountable, like finding Shane Meehan unfit to stand trial when clearly he was fit enough to run for mayor. So how is he now unfit to stand trial when he went and assassinated an FBI agent in your state? That's bloodlust, sir. It's not us out here wanting information and transparency. As far as the public's desire to learn about access to court records, that educational effort cannot be by this officer educating each individual ad hoc whenever they choose to seek public information. Well, why not publish everything on my case like you're supposed to and exhibit extreme transparency? Why not have had court cameras in those courtrooms from day one and relieve the public's suspicions about what's going on there in Carroll County? All right. Sorry, I'm having extreme difficulty with the sinuses. I am a little ill with allergies. Nose is running. Let's see. All right, you guys are not going to like this, but we got more. We got more. So what I'm going to do, because I think not enough people have focused on this. We're going to continue to speak about some bloodlust. In that we're going to review briefly the various Frank's motions. Now, what I mean by that is you're probably very familiar with the Frank's memorandum, which we've gone through ad nauseum. And by we, I mean myself, Rick Snay, and Joe Lewis. We have each read through in its entirety the Frank's memorandum. All 136 pages. We've gave our commentary as well. So we've drove the Frank's memorandum home pretty well for everyone. And it's all still available for those of you who are interested, who may not have already familiarized yourself with the Frank's Memorandum. I encourage you to go and look on my channel. There's a playlist, okay, called A Deep Dive into the Frank's Memorandum. And on that playlist, we cover in depth the Frank's Memorandum. We go through it word for word, okay, over the course of maybe 5 or 6 episodes. So if you're interested in the content of the Frank's Memorandum, it's there for you on a playlist. So it's there. But for now, we're going to cover this, the basics of the Frank's motions, the various 4. I want to go through them and just touch on the highlights, okay, because these are often ignored or bypassed because when we speak of the Franks, we specifically lean on the Frank's Memorandum, the 136 pages, which was really the meat of the Frank's motions. But the motions themselves are very interesting. Okay, so we'll cover this. We'll cover this tonight as an added bonus, and because it does touch upon the bloodlust, and this is going to give us some information. So, okay, let's continue. Let me see. I want to unplug this at this moment to free me up so I can relax a bit. Okay. All right. So this is motion for Frank's hearing, okay, on September 18. This is what started the ball rolling. And we're going to skip ahead to number 2. The affidavit for search warrant was also approved by a signatory, Prosecutor Nicholas McClellan, before being sent to Judge Benjamin Diener for further review. Okay. The purpose of said affidavit for search warrant was to provide a sworn statement containing information from that lengthy investigation that would convince Judge Benjamin Diener that a reasonable belief existed that evidence of said murder would be found in Rick Allen's home and vehicles. And now you know that it wasn't. Okay. 4. The affidavit for search warrant was apparently reviewed by Judge Diener, who then signed a search warrant for Rick's home and vehicles at 6:37 p.m. on October 13, 2023. That on its face and within the 4 corners of the document, the affidavit for search warrant was defective in that it did not provide the type of information that would cause any reasonable person to believe that it was more likely than not that evidence of the murders of Abigail Williams and Liberty German would be found in Rick Allen's home or vehicles, especially more than 5 years after they were murdered. Okay, because of on its face and within the 4 corners of the affidavit for search warrant, no reasonable person would believe that it was more likely than not that the evidence of the murders of Abigail Williams and Liberty German will be found in Rick Allen's home or vehicle. Judge Diener erred in signing said search warrant. Therefore, any search of Rick's home and vehicles was illegal. Therefore, all items seized pursuant to said illegal search should be suppressed. Okay. And what we call that, ladies and gentlemen, would be the fruit of the poisonous tree. Fruit of the poisonous tree is the argument being made here. And keep in mind that none of that evidence did prove Allen had any involvement whatsoever in these murders. However, the evidence from the search warrant was used, particularly when it comes to the firearm that was seized, the Sig Sauer P226. There was a witness for the state, the ballistics expert, who alleged that the unspent round found at the crime scene matched a fired spent cartridge from Mr. Allen's gun. And we know that that is not very reliable evidence. It's almost inconceivable that it would be put forth by an expert. But for an expert who is attempting to support the state's contention that Mr. Allen is involved, it can be assumed that such an expert might want to prop up the argument of the prosecutor here. So, 7. However, making matters far worse, Detective Tony Liggett chose to hide crucial information from the search warrant affidavit and provided false statements in said search warrant affidavit. Now, that's 2 amazing statements there. Incredible statements there. Tony Liggett chose to hide crucial information and provided false statements, meaning lied. Okay. Continuing, number 8. Defense is required to make a substantial preliminary showing that omitted or false statements were made knowingly or intentionally or with reckless disregard. Okay, and we do believe that these statements were made knowingly and intentionally and with reckless disregard for the truth. And if the trial court concludes that said omitted facts or false statements were necessary for finding of probable cause, then the trial court should set a hearing, okay, for Franks. Number 9. Furthermore, Indiana courts have held that when material information is omitted from a PCA, such omissions will invalidate a warrant. So here, question. What was omitted? Well, I'll tell you the major thing that was omitted, in my opinion, is the statement that one of the vehicles that was transformed into Mr. Allen's Ford Focus was described as resembling a 1965 Mercury Comet type of vehicle, one which the witness was very familiar because her father had owned a 1965 Mercury Comet. So some vehicle that's very, very close or very similarly resembles a 1965 Mercury Comet would be the type of vehicle that was witnessed by this particular female witness. That particular detail was omitted from the search warrant. It's an important detail. Okay. I'm going to skip ahead. Number 10. Rather than hiding said information from Judge Diener, had Liggett actually included said information within the affidavit for search warrant, then Judge Diener most certainly would not have signed the warrant, as the hidden and false information was the type of information that any reasonable person would have known was the kind of thing the judge would wish to know. Yes, like that the witness said muddy for the first 2 years in all interviews, at least 20 or more times, and never said the word bloody once. And that only after 2 years and after the 3rd interview did this witness suddenly say bloody exclusively and not repeat the word muddy not even one time, saying bloody 16 times or more. That's the type of information that any reasonable person would have known, that it's the kind of thing the judge would wish to know. Okay. So defense asks the court to incorporate this memorandum, the 136 pages I was just referring to, into this particular motion. So like I said, if you're interested in that 136 page memorandum, go and look in my playlist for a deep dive into Frank's memorandum. Let's continue. Supplemental motion for Frank's hearing. October 2nd, 2023. Okay. We're going to continue to number 2. To mandate an evidentiary hearing, the challenger's attack must be more than conclusory and must be supported by more than a mere desire to cross-examine. There must be allegations of, quote, deliberate falsehood or of reckless disregard for the truth. And those allegations must be accompanied by an offer of proof. Okay, so I just reiterated to you that the deliberate falsehood would be by Mr. Liggett, and the reckless disregard of the truth also. And like I said, the omissions of particular pertinent details, like the witness who was describing a 1965 Mercury comet. Okay, we're going to skip down here to paragraph 3, second half of it. It says, put another way, the preliminary burden must be sufficiently rigorous to preclude automatic hearings in every case. Meaning there must be some reason for a Frank's hearing, okay? But not so onerous as to be unachievable. Do you understand the meaning of that? Okay. Do you understand the meaning of that? The preliminary burden must be sufficiently rigorous to preclude automatic hearings in every single case, but not be so onerous as to be unachievable, which this biased judge has allowed. Therefore, Allen's burden could be akin to the well-recognized burden of reasonable suspicion, the lowest of standards employed in the criminal justice system. But as we see, our judge has made it the highest standard. All right. On to paragraph 4. At its very foundation, the preliminary showing requirement is intended to discourage litigants from utilizing the suppression process as a means of seeking additional opportunities to cross-examine state witnesses. Hence, the rule requires the defendant assert more than basic allegations. Instead, defendant must offer up affidavits and other supporting documents to prove up defendant's claims that state actors engaged in conduct that demonstrated intentional or reckless disregard for truth. Okay, we'll skip ahead. We're going to move here to paragraph 7. In this case, defendant Allen has done far more to offer up self-serving, than offer up self-serving affidavits. In fact, the bulk of supporting documentation in defendant Allen's offering includes, but is not limited to, affidavits from law enforcement officers working the case. Think about how rigorous this was, okay? Please, that the 136-page memorandum is what's being referred to here, okay? It's very rigorous. Continue. Sorry, I got upset. Okay. Affidavits from law enforcement officers working the case, Todd Ferentz Click, sworn deposition statements from law enforcement officers, Holman, etc., numerous police reports, and audio and video of witness statements taken by law enforcement officers during the investigation, and especially what we're discussing here is regarding the Rushville investigation, the Odinite or Odinis or Odin or Click investigation, Click report, Odin report, whatever you want to term that as. The veracity of the supporting material offered up by defendant Allen is far more reliable on its foundation than self-serving affidavits offered up by the defendant in People versus Luciente. Therefore, it stands to reason that defendant Allen would likewise meet the requisite burden of proof for the preliminary showing, such that his Frank's evidence should be admissible at the suppression hearing. Remember, the standard should be one of the lowest standards, right? Because it's not supposed to be so onerous as to be unachievable. All right, we're going to continue. We're going to skip ahead to paragraph 9. Again, defendant offers up a self-serving affidavit supported by corroborating business record and met his burden as it relates to a preliminary showing. This is citing the precedent for the standard being a low standard for the granting of a Frank's hearing. Defendant Allen's memo, which we mean is the Frank's memo, and the attachments, which means all the evidentiary attachments to that Frank's memo, amount to far more. Allen offered up dozens of pages of police reports. That's exactly right. Police reports. Law enforcement product, both from local law enforcement and the Indiana State Police, and with the involvement of the FBI. all of which focus on individuals other than himself that could have committed these crimes. By that, we're meaning the third party evidence or particular exculpatory evidence out of that Frank's memorandum and all the attached evidence. Okay. Assuming that the necessary deposition transcripts from law enforcement officers that contain testimony acknowledging that others may have committed these crimes. And finally, both written and recorded statements of witnesses on or near the trail on the day in question, who articulated facts entirely inconsistent with those offered up by Sheriff Liggett. Now listen to that again, because I don't know if you know that this exists. Both written and recorded statements of witnesses on or near the trail on February 13th, 2017, the day in question, the time in question, who articulated facts entirely inconsistent with those facts offered up or alleged facts offered up by Sheriff Liggett. Do you understand? This is important. Assuming that the necessary threshold showing has been made that a hearing must be held, the next question revolves around who has the burden of proof and what exactly is the legal standard for the suppression hearing or at the suppression hearing. Franks holds that the allegation of perjury or reckless disregard must be established by the defendant by a preponderance of evidence. The standard and the circumstances surrounding evidentiary showing are referenced in paragraphs 6 to 10 of Defendant Allen's motion for Frank's hearing previously filed and that we just read. Okay, let's continue. Defendant Allen's additional Frank notice from the next day. Okay, the additional Franks from October 3rd, 2023. Here we're going to go again. Number 2. Since filing the Franks motion, the defense has received new discovery that strongly supports the defense's belief that Tony Liggett and Unified Command attempted to conceal from Judge Diener, and even since has attempted to hide from the defense. That evidence supports those practicing Odinism were the murderers of Abby and Libby. Specifically, Tony Liggett swore under oath at his August 8, 2023 deposition that a Purdue professor did not believe the sticks found on Abby and Libby's bodies consisted of runes. But we know that's a lie now. Furthermore, Sergeant Jerry Holman, affectionately referred to as Jer, swore under oath at his August 10, 2023 deposition that a Purdue professor said the sticks found on the girls did not represent Odinism or any type of cult worshiping or any type of group that would have committed the crime. Okay. Then it talks about how McClellan tried to hide the identity. But however, on September 19, 2023, the day after the Franks memo was filed, where it was revealed to the public and to Jerry Holman that the Purdue professor was missing miraculously, Jerry Holman coughs up the professor. Yes, he coughs up Jeffrey Turco and interviewed him. Remember what else happened is that the Odin patches mysteriously, immediately disappeared from the guards at Westville. Continuing. Oh, I'm sorry. Okay. Number 10. It was obvious that the Purdue professor would probably out himself as the missing Purdue professor following the Franks memorandum's release. Holman went and interviewed him the day after the Franks was filed. You see, that's called, oh shit, emergency ejection, emergency shoot. Okay. 11. Why would Holman and Unified Command try to hide the name of Jeffrey Turco? A. Turco stated that after viewing the pattern of the sticks on the girls, quote, it was a given that someone was trying to replicate a Germanic runic script. That's important, paragraph A. B, Turco consulted with a colleague from Harvard who had even more knowledge of runes, and this Harvard professor was in agreement with Turco that it was a given that someone was trying to replicate a Germanic runic script. Furthermore, Turco stated that Odinism is an extremist neo-pagan neo-heathenism. That's the key word there. That's the key word, heathenism. Don't get stuck on Odinism. Get stuck on heathenry. It's an extreme ideology that has right-wing racist connotations. Although they will deny it, it is true. Furthermore, Turco stated that although he could not necessarily interpret these runes, that the stick configurations were pretty clearly runic, and quote, that he could certainly imagine that this was somebody's idea, that when you do human sacrifice, you make runes. F. Turco discussed how runes were thought to have magical, this is quotation, magical significance and would be used in incantations, in rituals, and that there is a sacrificial connection in mythological poetry. Those were things, again, where somebody who was sort of an Odin fanboy would likely come across, close quotation. This is not what people have made it out to be. This is not what Troll Farm has told you it is. Oh, sorry, I skipped. Hold on. Do you guys understand, though, why people say that these are good attorneys, Baldwin and Rozzi? No, I did not say hedonism. I said heathenism, heathenry. Okay. We're quoting from this document is what I'm doing. Quoting from this document. 14. It seems apparent by the timing of events that Tony Liggett and Unified Command knew the professor's name and wanted to hide his name. Okay, because his conclusions supported the defense theory and opposed the prosecution's theory and sworn statements. Remember, it made them into liars. It made Turco's conclusions and quotations from Turco directly made Liggett and Holman liars when it comes to what they were relaying. Do I need to back that up for you? Remember, Tony Liggett swore under oath on August 8, 2023, in his deposition that Jeffrey Turco did not believe the sticks found on Abby and Libby's bodies consisted of runes. Okay. 2 days later, August 10th, 2023, Jerry Holman swore under oath that Jeffrey Turco said the sticks found on the girls did not represent Odinism or any type of cult worshiping or any type of group that would have conducted this crime. Do you see? Again, Franks requires a preliminary finding that law enforcement has acted intentionally or with reckless disregard for truth when being accused of concealing evidence from the judge who signed the warrant. It will be difficult to find a more outrageous set of facts to support that Liggett and Holman intentionally concealed the Odinite information or heathenry or the expertise of Mr. Jeffrey Turco and the Harvard professor From Judge Diener. If Liggett and Unified Command were willing to try to get away with concealing Jeffrey Turco from defense counsel, then it's easy to see why they would have no problem concealing all other evidence and evidence detailed in the Franks memorandum. Okay. Do you see why I'm saying these are important? Because the points these amazing attorneys are making are important points that have been railroaded on by our judge, Francis Gull. Okay, here we go. This is now April 29th, 2024. So jumping ahead quite a bit, quite a bit in time comes defendant Allen's fourth Franks motion. Okay. Mr. Allen filed his first Franks, which included a 136-page memorandum, which detailed the following evidence that Carroll County Sheriff Tony Liggett failed to include in his search warrant application. Evidence that was detailed in the search warrant application that was false. Evidence that there was an intentional effort and multiple instances of attempting to conceal evidence from the defense and failing to tell the truth under oath concerning certain evidence. Okay. Now we're going to skip ahead. The second Franks detailed how the prosecution and law enforcement attempted to conceal the identity of Jeffrey Turco. You see? Number 5, down here in the middle of the page. Third Franks detailed the following, omitted from the search warrant. At least 3 persons were around or in and around the crime scene at the time the murders were allegedly taking place. 3 persons. Those are the 3 persons in the geofencing. None of the owners of the phones had a connection to Mr. Allen. B, Jeffrey Turco wrote in a report that the markings referring to the configuration of the branches on the girls' bodies constitute an inscription inspired by Norse runes or modern recreations thereof, that it's quite plausible. Okay. Additional facts. There we go. 2 pages from an incident report authored by Steve Mullen of the Delphi Police Department indicate that Steve Mullen contacted Sergeant Mitch Blotcher of the ISP at approximately 9 p.m. on February 13th, 2017 to assist with acquiring precise location information for a cell phone using some of the more technical assets. It appears that the last communication with Sergeant Blotcher was prior to 1 a.m. on February 14th. The 2 pages provided to Mr. Allen's counsel contain the following summary of a conversation between Mullen and Blotcher. Sergeant Blotcher advised, according to his evaluation of the data provided by AT&T, that the last contact event between the cell phone and the tower located at Wells Street was at approximately 5:44 p.m. He advised that according to the records provided by AT&T, there had been no contact with the phone since then. Sergeant Blotcher advised that his interpretation of the information which we were receiving from AT&T indicated that the cell phone was no longer in the area or no longer working. He advised that since there had been no change in the every 15-minute update we were receiving, that the last contact time had not changed since 5:44 p.m. Conversation above appears to have occurred prior to 1 a.m. on the 14th. On November 9th, 2023, prosecution had provided Mr. Allen's counsel with evidence of 44 pings generated by AT&T to locate Liberty's phone. There were 2 pings from February 13th in the pings provided, one at 5:48 p.m. and one at 7:16 p.m. Mr. Allen's counsel did not learn of additional pings, which took place every 15 minutes on February 13th, 2017, until discovery disclosure on April 26, 2024. Defense counsel still does not have the additional pings. Okay. Pursuant to information which the prosecution disclosed to Mr. Allen's counsel, the first ping on February 14th was sent to his phone at 5:39:41 a.m. That doesn't make sense, does it? Okay, skipping on down. The prosecution's entire case rests on the idea that Liberty and Abigail were on or the south side of the Monon High Bridge at 2:13 p.m. and Richard Allen killed them between that time and when a witness allegedly saw a man in blue jeans and a blue jacket on 300 North shortly before 3:57 p.m. In other words, assuming that the prosecution's evidence is accurate, Liberty Germ and Abigail Williams were murdered after 2:13 p.m. and before 3:57 p.m. Additionally, assuming this timeline is accurate, the prosecution would have the girls between the High Bridge and the location where the bodies were found from 2:13 p.m. on February 13th until they were found at approximately 12:15 p.m. on February 14th. Well, that's extremely unlikely, as you all know. Okay, at the time of the bodies were found, the phone was under Liberty's shoe, under the body of Abby Williams. Apparently, this, according to state, this phone had remained there. Okay. However, Sergeant Blotcher stated on February 13th, 2017, that the cell phone was no longer in the area or no longer in working condition. There's no way that Liberty's cell phone could have been out of the area between 9 p.m. on February 13th and 1 a.m. on February 14th if the prosecution's timeline is accurate. There was no way that the phone is not in working condition between 9 p.m. on February 13th and 1 a.m. on February 14th because the phone was on and communicating with the cell tower at 4:33 a.m. on the 14th. For the prosecution's timeline to work, the phone had to have been in the same condition from sometime prior to 3:57 p.m. on the 13th until the bodies were found at 12:15 p.m. on the 14th. So you see why it doesn't make any sense whatsoever? 0 sense, never will make sense, never, ever, ever, ever will it make sense. Let's continue. Now, all of these points here are hypotheticals, okay? Hypotheticals. It says, had Tony Liggett submitted an affidavit that did not recklessly disregard the truth, it would have included the following points, okay? It would have said, when the bodies were found at 12:17 p.m., there were sticks and branches which appeared to have been deliberately placed. Says Nicole Robertson stated the bodies appeared to have been moved and staged. Abby Williams was dating Logan Holder. Logan Holder is the son of Brad Holder. Jerry Holman, an ISP, consulted with Jeffrey Turco. Jeffrey Turco wrote in a report that the markings constitute an inscription inspired by Norse runes is quite plausible. Brad Holder belonged to a group practicing and following Nordic pagan beliefs. Brad Holder posted pictures on Facebook mimicking the crime scene. Libby and Abby were killed after 2:13 and before 3:57, according to the state. During that time, there were 3 fucking phones in the area where the girls were last seen and the location where the bodies were found. None of these phones belonged to Richard Allen. Get it? Then it goes into the pings on the timeline. The last ping was 5:44 p.m. And remember, at 5:45, someone plugged something into that jack. And at 5:49, one of those 3 phones left the geofencing area. And it was not pinged again until 4:33 a.m. on the 14th, at which time it magically came on and received a bunch of fucking pings. ISP believed Liberty's cell phone was either out of the area or not in working condition. Oh, that's the hypotheticals, right? These omissions are so voluminous and significant that there's no explanation for their omission other than a reckless disregard for the truth. And that's putting it nicely, in my opinion. Had Tony Liggett not recklessly withheld pertinent information, the search warrant application would have been denied. Okay. Now, give me a moment. Remember that when we covered the Franks memorandum, there appears to be much, much, much more incriminating evidence among this entire group. That's a result of the Todd Click, Kevin Murphy, Greg Ferenczi investigation. Also a result of a lot of the words of parties like Taylor Hornady and Elvis Fields and Amber Holder. It's quite stunning, the amount of information. There's just no explanation. There's just no explanation. Okay. But let's continue. We're discussing Bloodlust. Okay. And I'd like to remind you before we move on to this, keep in mind how odd it is. Keep in mind how odd it is that when Scrimmin and Libredo were assigned to defend Mr. Richard Allen during the time at which Baldwin and Rozzi had been forced, and let's say this very clearly, Baldwin and Rozzi had been forced or intimidated to withdraw from the representation of Mr. Allen by this judge, who then brought in Scrimmin and Libredo. And it was the Supreme Court who forced Mr. Baldwin and Rozzi back into representation, which was subsequently followed by another attempt to have them pulled from the representation of Mr. Allen. Not just an attempt to have them pulled from representation of Mr. Allen, but to an attempt to have them jailed. Just like Mr. Click was jailed, there was an attempt to have Mr. Baldwin and Mr. Rozzi jailed. And that effort was cut short by basically the revelation of the malpractice of the employee of the court. By that, I mean the assistant to Miss Gull had acted inappropriately with YouTubers. And these YouTubers thereby threw a wrench in this entire scheme to have Baldwin and Rozzi jailed. And so they were therefore not found in contempt. But oddly enough, they were scolded in that finding of no contempt, which is a whole other thing regarding this judge's attitude. But back to Scrimmin and Libredo, the interesting thing there was that when Scrimmin and Libredo were in their brief tenure as representatives of Mr. Allen, our judge did offer them an open pathway to a Franks hearing. Now, isn't that interesting? Isn't that interesting? It's actually insane if you think about it. Because in this hypothetical system that our courts work in, the lawyers are not supposed to be independent from the client. The lawyers are merely representing the client's best or interests. So they are there as as stand-ins for the client. Physically incorporated as physical representatives of the client is the hypothetical that our courts operate under. But no. In this case, when the attorneys changed, they were offered a different outcome than the prior attorneys. Now, how on earth does that make the attorneys incorporated representatives of the defendant? That is treating the defendant differently depending on who is representing him, which is not supposed to be the way it works, but that actually happened. And keep in mind, when Mr. Libredo was no longer representing Mr. Allen, he did make it a point to have a conversation with a young lady, a journalist, in which he said, it's actually frightening. One girl was murdered and one girl was sacrificed. One girl was killed and one girl was sacrificed. It's scary. Yes, he did. Yes, he did. You're talking about someone who would have reason to know, who saw the discovery, who was familiar with the investigation, and who honestly looked shook. Keep in mind, we are discussing the bloodlust of Central Indiana, the blood and the lust in the community. One girl was killed, one girl was sacrificed. Let's move on to this I want to show you. The state of Indiana provided two undated reports never seen by the defense. The first report provided some detail as to how the state of Indiana explained that certain videotaped recordings between February 14th, 2017 and February 20th, 2017, which would include Brad Holder's interview, were erased magically, miraculously, mysteriously. However, the other report details how all videos between April 28th, 2017 and June 30th, 2017 were also lost. This is news to the defense, as the defense was unaware or was aware that certain videos did not contain audio, but was unaware that videotaped interviews between April 28th, 2017 and June 30th, 2017 were missing. This is most concerning, don't you think? C, based upon the paragraph 5A2 above, the defense would be requesting the court to compel the state of Indiana to provide a listing of all persons whose interview was videotaped but lost. But unfortunately, again, according to the state of Indiana, there's no comprehensive written log that was used to document date, time, and subject and participants for each interview room. Meaning, not only did you delete it all, lose it all, disappear it all, but you don't even know what you lost. You can't testify as to who was interviewed. Absolutely mind-boggling, completely unacceptable. Again, this is extremely concerning to the defense and Mr. Allen because potential exculpatory witnesses and statements are apparently forever lost, and not even a log of which witnesses were interviewed and lost exists. It's just like the Marathon gas station, isn't it? Is it not? You don't know what's lost. Furthermore, it's very disconcerting that the defense just learned of this lost evidence and only upon request of the defense of such report in more than 14 months after the defense should have been notified of this. Totaling the missing days of interviews, February 14th to February 20th, 2017, and April 28th to June 30th, 2017, would show that the state of Indiana has lost an entire 70 days worth of interviews and claims to have no ability to account for who was interviewed during those 70 days. 70 days completely lost and no ability whatsoever to account for even one of those days. Seven, the defense requested the existence of certain phone dump data from certain phones. In response, the state of Indiana claims that no phone dump evidence exists from Kelsey German's phone or phones, nor Mike or Becky or Cody Patty's phones. And furthermore, that the prosecutor's office does not possess any phone dump data from those phones. However, it is still unknown whether that phone data dump evidence did exist at some point in time, which question is more than fair considering the loss of 70 days of investigative activity as referenced above. It would be hard to believe that law enforcement would not have obtained the phone dump data from the parties identified in this paragraph, Kelsey German, Mike, Becky, and Cody Patty, to at least determine timelines. Again, I think that's worth repeating. In response, the state of Indiana claims that no phone dump evidence exists from Kelsey German's phones, nor Mike, or Becky, or Cody. Furthermore, the prosecutor's office doesn't have it. It would be hard to believe that law enforcement would have obtained the phone dump data from parties or would not have obtained the phone dump data from those parties, Kelsey, Mike, Becky, and Cody, to at least at a bare minimum determine timelines. The defense would compel the court to order the state of Indiana to provide all geofencing data and the names of the actual persons or persons that interpreted the geofencing data. You see? And they try to withhold that, though. That too. Okay. Please give me a moment. Thank you so much for being here. There's a lot to get through, so difficult. So it's clear. It should be pretty clear why people are not happy with this. So through this entire process, all of this has angered me quite a bit. Look, while I'm doing this talk, let me do this. Let me do this while I do this talk. I'm going to play some videos in the background while I do this little talk. This right here you're going to see is a video from my channel that I took when I was in Delphi last year, about a year ago this time. Took this about a year ago. And it's on the channel if you want to go watch it yourself. But here I'm flying my drone. This is going to be a flight in which we go over the high bridge. And then we circle around the Weber property and go on over to Ron Logan's and come on back. So while I talk, you can look at this. This has been a very upsetting endeavor. Because you have for years an entire narrative was produced. An entire narrative. Matter of fact, I've said it many times. For every single possible aspect of this case, there's been a detailed narrative produced. It's almost as if they staged, or I'm sorry, they reverse engineered a scenario based upon the evidence they knew would exist. Like the time the girls were found, the place they were found, the manner in which they were found, the evidence that they knew would be existent, like the photographs. Keep in mind that on that day, nearly everyone out there was taking photographs almost as if to establish a digital trail. Do you understand what I'm saying? And you have to think, if all that was done by conspirators, and if the guilty parties knew all that existed and what would be found, they could reverse engineer a scenario. And I think that's exactly what happened. I think it's no accident that everyone out there had cameras, was establishing a digital footprint, created a timeline, and then they look back and they reverse engineer a perpetrator. They say, well, what it looks like happened is that the girl saw someone on the bridge. That person abducted them, walked them across the creek, made them get naked, and killed them. And so then they've engineered a motive, which is sexual, and a POI, which is an adult male, lone wolf killer. It therefore must be a crime of passion, right? So they know that whatever trouble ever comes, what has to be done is that a lone wolf, middle-aged male, sexual perpetrator has to be established, found, created, caught. And hey, it's kind of like JFK. It's kind of like JFK. Because with JFK, you had multiple perpetrators. You had people pre-positioned. You had people running interference, distraction. Of course, afterwards, you had narrative control, spin, a conspiracy, a whole story. And you had a patsy. And you had a whole story about the patsy. And when the shit got too hot, you killed the patsy. JFK. They blew his head off in front of the entire world. Literally. on the world stage. Now, how long has that been secreted? Now, you see, the thing is that the problem with conspiracies is that more than one person knows. Which means secrets can't be kept forever. They really can't. Matter of fact, with this group of retards, secrets probably couldn't be kept one day because it seems like a whole lot of secrets got told. But people have ignored it for 7 years because the mainstream narrative push was so strong. You had the family go all out on an all-out media campaign. Podcasts, magazines, billboards, conferences, television shows. Full-on media assault. It took that tidal wave to keep this under control because remember, if you had a bunch of individuals, facts were leaking out. They had to make those facts seem like lies, rumors, conspiracies. And so it took a significant media campaign. And apparently, it worked. Of course, in my opinion, a bunch of people had to die along the way. A bunch of people had to be paid. A bunch of people had to be blackmailed. And a bunch of people had to die. But look, they achieved their goal. Right here, you have the woods at Wilson Bridge. Who knows what happened out here? Oh, this is much more secluded than Ron Logan's, isn't it? And Brad Weber's. Yes, it is. Browns live right here. Browns. Yes, they do. Derek was right here. Yes, he was. This is Mears' property. Mears on one side, Browns on the other side. Mears and Browns. Oh, and the effort was made to put Derek right here, right before he ends up at the trails. He's right here, right in this spot right here. I filmed this in mid to late November, and it looks just about identically as it would look in February. You can see everywhere. Yes, you can. You can put a canoe in that water so easily from this spot. You can see things perfectly. There's not a leaf on a tree. As a matter of fact, this is where you would put in a canoe. Rumor has it that this is where Mike put in a canoe that very night. The same night that the horrific screams, the bloody murder, the screams of death were occurring. Horror screams is how they were described. And right here, where would you take those girls to do bad things to them? It's just a question. Especially if you don't have much yourself. Let's just say you don't have your own home or business right here. Where would you take those girls to do bad things to them? Maybe someplace secluded like this? It'd be awfully easy to move those girls from here, whether you go through the water or through the woods. Either way, it's easy. You see, like I said, people have had a hard time not talking. No, Niobe. It would be smooth sailing because there was 2 extra feet of water in the creek that day. 2 extra feet of water. It wasn't looking like this. No, baby. It would have been smooth sailing. You see, if you had several people, they couldn't keep a secret. They couldn't keep a secret. It was too exciting or too emotional an event. You couldn't keep it secret among too many people. So what happened? What really happened? Those girls were not there in Ron Logan's from 2:32 p.m. I'm sorry. I'm sorry. There's no way. No way on earth. Those girls were brought somewhere, and bad things were probably done to them. Remember, there is unknown male DNA on their bodies. Yes, there is. I think bad things were done to them, and I think people know that. And that's given rise to these rumors. For years, people have said, there's a film of those bodies. There's a film of those murders. There's photos of those bodies. There's photos of those murders. And I begin to wonder, really, what is there photos of? What is there film of? Is there film? Or is it photos? Or is it photos or is it film? Did someone bring cameras or did someone bring a phone? Whip out a phone. Did someone try to do sexual things to these girls? I mean, they were both naked. At some point in time. And one ended up reclothed. So what really happened? See, something ain't right. And that's the reason that people will not let it go. People understand that something is not right. People always have understood that, actually. It's not that hard to see. I actually want to stop it there and show you something. Let me back it up. You see here? This is the little parking lot pull-off area, gravel parking spot. This is where you would park your vehicle if you were going down to the woods. See? I guess I'll talk you through this here. This is the path, okay? This is the path that leads from the parking lot down into the woods. These are the woods. This is why it's easy to put a canoe in here. You see? So I'll let this in and continue because this is on the channel for those of you who are interested in looking closer. It'll be there. It's not wilderness. It's not like untraversable. Okay. What I'm showing you, they're clear footpaths. Now, what did I mean by more to come? Well, I meant disclosure. So I want to talk about this because I'd love to play you this clip, but see, the YouTubers are in war mode. Okay, they're in war mode, so you can't play nice clips from Delphi YouTubers because it's all chaos. It's all chaos. So I have to read transcripts from Delphi YouTubers. That's right. It says, so we have Garrett Kurtz saying Ashley was talking with Sheena Cottrell. Sheena Dillon, and Nick Edwards about the murder tape. But the question is, are we talking about a murder tape or a sexual tape or photographs? You can see things get twisted, things get fuzzy. But it seems like we're talking about footage and victims, whether they be alive, dead, whether it be film or photography. We're talking about some type of footage of the two victims in some scenario, whether it be dying, being killed, sexually assaulted, performing sex acts, nude. We don't know. But it seems like there's a line of rumor that may have some foundation. So Sheena Cottrell and Nick Edwards were talking with Ashley Garth, according to Garrett Kurtz, about the murder tape or footage of the girls. So all we have to do is look as far as a couple blocks away to realize that these people, she lived in this part of Peru, just a few blocks over from Keegan Kline. If anyone would do their homework, there's a lot more people in the area, names that are consistent. Jason Palladino's ex-girlfriend, Sheena Cottrell. Garrett Kurtz is attached to Ron Logan, and the girls were found on Ron Logan's land. They were probably told to meet on the south side of the bridge, right where it would be a trap zone. He and Keegan Dunker, Austin Popejoy, Keegan Kline, they all attached to each other. And then on top of that, there's a mask. Sheena Cottrell and Garrett Kurtz is talking about Sheena Cottrell and knowing about the murder tape or stuff like that, or snuff film or something like that. For instance, they control everywhere. So no matter where you look, that name is around. There's all over the map. But Garrett Kurtz talking about Ashley and Sheena and Nick Edwards. Yet, look how close they live to each other. Right there. Blocks away, it's a small town. You know? And she says, Jason Palladino connects to Sheena Cottrell. Sheena Cottrell is right down the road from Keegan Kline. It makes sense that Sheena and Jason Palladino, that they knew about Keegan's Dropbox. And the revenge side comes on the other side again of Delphi with the girls. You got Libby's nude covered with sticks. So that's the reason that if you have somebody that's in the child PORN, or whether it's the dad or whatever, and then you have Libby's body naked, you know, then you have Keegan looking up about DNA. Remember, Keegan searches about DNA. But it's plausible that Keegan Kline, because he's good with videos and making videos, it's plausible that he was there filming. That's what she's saying. Because Keegan goes over there, he talks about it, and he's missing this part here. And when you read the transcript, he's clearly, you know, a full-blown liar. Hence why perhaps, like, if two people are using phones and they can tell they're two different conversations and they're pinging in the same area, again, you look where Sheena Cottrell lives in Palladino. Maybe they're meeting him, or maybe, who knows, maybe knows the Palladinos, or maybe Palladinos with Keegan Kline or whatever, texting. Who knows where the phones were pinging from? Remember, pings are not that accurate. So maybe Jason Palladino and Keegan Kline, where Keegan was trading nude pictures for pot or drugs or other drugs. At the end of the day, to me, there's this connection that goes from the Palladino side and Garrett Kurtz side to the Keegan Kline side, the Nick Edwards, the Sheena Cottrell, the snuff film. You got talk of murder tapes and about Ashley and Sheena Cottrell and Nick Edwards. So I think this is one of the closest connections to understanding that Jason Palladino, that this would be the revenge. I'm just saying my thoughts would be revenge. For all I know, Palladino says Jeff Reagan, or whatever his name is, you know, again, who knows, but good druggies are best friend druggies or whatever. All I'm saying is, to me, this is one of the biggest connections to look at of anything we've looked at. And it's not hard. It takes a lot of time, don't get me wrong, but to me, that Jason Palladino, if anyone knew that Dropbox, it's probably going to be him, you know, like him and Garrett, because I keep my head going back to Keegan Kline sharing Pope Joy's post that Keegan Dunker commented, made a happy birthday comment, and why isn't he on the friends list anymore? Okay. And that is Sonny Justice. Speculating. That's Sonny Justice speculating. But you know what? I think it's some interesting speculation. I really do. She's got a point there. Sheena Cottrell, Jason Palladino, Keegan Kline. Pings are not that accurate. Dropbox. Naked Libby and Abby. Nick Edwards. Garrett Kurtz. Ashley Garth. Like I said, there's a reason for the rumors. So why are there the rumors? Why were those girls nude at some point? Why is there unknown male DNA on those bodies? Why is it compromised? Why was Abby redressed? Why does Abby appear to be injured differently than Libby is? From Facebook, Julie Parks makes a good point. The dark web makes up about 90% of the internet. The origin of the internet is American. The CIA, NSA has full access to the internet, including the dark web. It's literally their job. This case is global, according to social media and Doug Carter. Libby Snapchat friends list shrank on the 14th. Remember the deletions? Many names were unfriended from her account on the 13th. We also know Libby was on Snapchat that day, or at least her Snapchat account was active, to be more accurate. Everyone in the beginning directly lied about a social media connection. This case made it to the desk of the head of the FBI, James Comey, twice in 2 months. There were actually daily briefings from the FBI. And then ultimately, the FBI is removed from the case, asked to hand back the evidence. This is extremely confusing because the FBI could literally take over the case if they wanted to. It fits the criteria for a federal investigation, which is crimes against children, cyber crimes. There were many details released in the beginning by locals. By the locals. It was all over social media. Everywhere you look, there was info. But now there's nothing. It's all been sanitized. Even the comment sections. Nothing from 2017 or 18. It's all been scrubbed. This is an extreme amount of content to be scrubbed. How did they know of every comment that was important or every story in order to delete it? What about they found our girls? Was it the 70,000 plus tips that pointed the way? Interesting, right? Interesting. Was the search the crime? Were the witnesses the criminals? Were the tips on what to deal with? Is everything inside out in this case? A December 2014 study by Gareth Owen from the University of Portsmouth found that the most commonly hosted type of content on Tor, or the dark web, was child pornography, followed by black markets. Well, that would be where you'd go if you wanted to buy some type of stuff like this, would it not? Pictures of dead children, pictures of the murders of children, pictures of the sexual assault of children, videos. Is this the bloodlust of Carroll County? From Daniel Norfleet's PCA here. Remember, Daniel Norfleet, you need to look up who his neighbors were, who owned the houses right next door to him. Daniel Norfleet, Delphi. On the desktop computer of Daniel Norfleet, there were over 1,200 notable file images of CSAM and child erotica. There were 2 images specifically that show various female children, approximately 7 to 9 years old, fully nude in different sexual situations. There are 3 additional photos of female children, approximately 4 to 6 years old, fully nude in different sexual situations. Finally, there's a photo of a female child, approximately 12 to 14 years of age, fully nude in sexual situations. The search history on this device is comparable to that of the laptop, with several searches for child pornography. Additionally, this device was used to access the peer-to-peer file sharing network called Ares. There are 18 search keywords documented, which only 2 different terms were searched. Those terms were PTHC and bestiality PTHC, which means that Mr. Norfleet was searching for teen hardcore and pre-teen hardcore bestiality content. There are also 10 different Onion router URLs documented, which is an internet browser used to access the dark web and is known to be utilized due to its levels of anonymity. You get it? He's using Tor as the 2014 study showed. Most commonly hosted type of content on Tor is child pornography and black market. So if you wanted to buy some of this stuff, especially some real life snuff film or famous victims in compromising situations like Libby and Abby, wouldn't you go to the dark web to try to find that stuff? Remember, Robert Fortson did say that he found the crime scene photos on the dark web in a very evil, dark place. And guess what? There were other Delphi YouTubers who say they've absolutely seen the crime scene photos years ago on the dark web. I didn't make it up. I'd like to close it out. Okay. Let's see where we are. Before I read this, let me come back to you. Hello, everybody. I know I've been in miniature for the bulk of this show, but there was a lot of reading. Thank you so much for being here. I must say, being tuned in to this entire trial, I was most upset, and to be honest, enraged by one thing, even more so than Sarah Carbaugh's combative testimony, or say ballistic expert Oberg testimony. I was most upset about Nicholas McClelland's closing argument. It was truly the epitome of gaslighting, abusing, and misleading an audience. Almost hard to sleep at night when you consider what he did in his closing argument. It's probably one of the reasons that the jury was easily malleable. Here we go. McClelland called February 13 a day this community will never forget. He walks through the BS standard narrative of how Abby and Libby ended up on the trail that day and when they went missing. McClelland said nobody thought anything bad had happened because that doesn't happen around here. McClelland then did the unthinkable. He showed the extremely graphic, horrendous, horrifying crime scene photos of these girls brutally slaughtered with close-ups. He traumatized the jury again. In his closing argument on a big screen TV, at the climax of this case, he throws gore, blood, slaughtered children, butchered children, right in the jury's face. Then he goes on. He shows Bridge Guy. He says, that's Richard Allen. He says, you can hear the fear in their voices on this audio. He says Allen was wearing the same clothes as Bridge Guy. But of course, he omitted the fact that all the witnesses are describing all black or tan. He says, hey, we found knives and box cutters and a blue Carhartt jacket at his house. But what he doesn't say is none of those tested positive for blood, for his DNA, for the girl's DNA, for the other girl's DNA. Absolutely clean. Every knife, every box cutter, every blue Carhartt jacket, every boot, every vehicle he was in. He still says Richard Allen had knives at home. Richard Allen had a blue Carhartt jacket. Just after traumatizing them with gore of Libby and Abby. He then says, when confronted by an aggressive Jerry Holman, see, what he didn't say is Jerry Holman said, you're fucking guilty of something, I'm going to fucking prove it. He didn't say that. No, he said, Allen became angry. In other words, not only does he own knives and jackets, but he gets angry when you scream and yell at him and use his wife. He says, Allen had a Bridge Guy starter kit. Yes, he did. Yes, he did. He then says, the expert says that Allen's gun cycled the bullet. He then says that Allen made confessions. Allen made confessions. He doesn't mention the fact that Allen underwent a significant psychological breakdown, a psychic break, a state of psychosis that was long-lasting and very real. He didn't say that Richard Allen confessed to shooting the girls and sexually assaulting them. No, he left all that out. He omitted that. He didn't say that Allen was being threatened to do so by Odinist guards, by other inmates who were threatening to kill him on a regular basis, and his family. No, he left all that out. He then tries to bring in the white van because it's not like the white van wasn't on the helicopter footage, and it's not like all the YouTubers talked about the white van for 7 years. No, he brings the white van in and makes that something only the killer would know, and every single YouTuber who's ever watched YouTube about Delphi. He then looks at Richard Allen and he says, "Bridge guy stole the youth and light out of Abby and Libby." It was no mistake that he chose to show those crime scene photos as he painted Richard Allen as bridge guy. And Brad Rossi gets up. It says, "There's a broken timeline." Absolutely correct. Bungled ballistics. Absolutely correct. False confessions. Absolutely correct. Digital forensics. Yep. Rossi said jurors should consider all things that the prosecution didn't want them to hear. Oh, Rich. Time and time again, he said, we had to do the state's job. And guess what? We still do out here in the real world. Because it's very likely that those killers still run free. He talked about the hours and hours of video interviews that were lost. He said the prosecution cherry-picked info from the eyewitnesses to suit a narrative or to build a narrative, and he's absolutely correct. And that's from the witnesses they chose to use. What about from the witnesses they chose not to use? He brought up Brad Weber and said Weber's gun was not excluded. Another fact. He talked about the confessions in Westville and said the prosecution only wants to talk about what Allen said after 6 months of little human contact and physical and mental torture. He brought up the videos of Allen in prison, videos of his torture, actually. You must ask yourself why they don't want you to see the truth. He talked about the magic bullet. Said the prosecution just wants the jury to believe what the state firearm examiner said. You couldn't exclude Brad Weber's. You had to fire a round to match it to an unfired round. He then moves on to the phone data. And that something was plugged into Libby's phone after Allen was out of there. And then it was unplugged later that night. The time during which he has an absolute solid alibi. Who handled that phone and plugged in and unplugged into that jack? Who were in the geofencing? Rossi said you should question the credibility of this investigation. And boy, is that not the understatement of the year? He says the investigators were desperate to make Allen fit their theory, and absolutely correct. He brought up the example that the forensic pathologist suggested the murder weapon could be a box cutter after his deposition and speaking with Nick McClelland 3 times. He then had a miraculous aha moment. Oh, yeah, maybe the murder weapon was a box cutter, even though I've already said it was a serrated bladed weapon. The state has completely ignored the theory of multiple people involved, which was a long-held belief by investigators, Razi said. It's a labor-intensive crime. He says, prosecutor asks you to use your common sense, and now's the time. The jurors, Allen came forward initially to try to help and stayed in Delphi for 5 years, working in a public service position in a retail environment. Even though he could have left, he could have gotten out of there. He stayed there 5 years. Never identified once. Think of this. You're telling me none of the witnesses who saw Bridge Guy or saw the man in all black on the trails ever went into CBS and saw Richard? Are you telling me Betsy Blair, Sarah Carba, Rayleigh Voorhees, Isabel Voorhees? Nobody? None of these girls went into CBS in a town of 3,000 people, tiny town. The one CBS in town. None of these girls ever went in there and saw Richard Allen. Oh, maybe they were doing like Becky Patty said, and I'm not looking for who's around. I'm looking for my makeup. Yeah. Maybe they pulled a Becky Patty. They only went in there and looked for their makeup, and they got the fuck out of there. Didn't see a single person working in there. Therefore, they never saw Richard Allen. They don't know who he is. Wow, that's rich. That's really rich. Mm-hmm. He says there's no DNA that connects Allen. Nobody ID'd Allen, and no trace evidence found in his car or any of his stuff. Even though it's muddy and bloody. He says the state's timeline has crumbled and the magic bullet is no more than a tragic bullet. He showed pictures of medieval torture methods. He says we've evolved as a society, but now we use solitary, which is much slower and more painful. He then showed pictures of Allen from his cell. Terrible photos. It says, a guilty verdict is an endorsement of this torture. McClellan rebuts and says, some of the defense witnesses are irrelevant, even though they did not even put up a third of their witnesses or experts because this judge would not allow it. But the few witnesses they were able are irrelevant, of course. He says the defense team has repeatedly said throughout the trial that words matter. So he says, why don't Allen's words matter? Well, if Allen's words matter, McClellan, I ask you this. Was one of those girls shot? Was one of those girls shot? as Alan's words said? Was there evidence that Alan molested those girls, as he said during these psychotic episodes? Didn't you have his daughter take the stand and say, no, he never molested me? Although he said that as well. If Alan's words matter, Mr. McClellan, then why don't the false confessions matter? Or are you picking and choosing, like with everything regarding Alan? Well, they then put the spin on the case, as they always do. As they always do. They put the spin that Abby and Libby are heroes. Libby took the video of Bridge Guy to be a hero, and Abby hid the phone under her body to be a hero. Well, who wiped the phone off? And if Libby was trying to be a hero, don't you think she would have zoomed in and really tried to catch that guy's face? So do you see the arc of emotion and the manipulative narcissistic abuse tactics that McClellan used on this jury? I've said before, those girls were not heroes. They were victims. Let's not make it something it's not. There's no need for them to be heroes. They were heroes in their everyday lives. I mean, both having drug addicted mothers and fathers, both enduring and progressing through life, surrounded by felons, drugs, neglect. They were already heroes. They don't need to perform some extraordinary act in the last moments of their lives to be heroes. Let's call it what it really is they were victims. They were victims of lust and bloodthirst in Carroll County. They were equally as likely to be murdered by a car falling on them, an unfortunate car accident, an unfortunate gun accident, or an unfortunate fire, because we know that seems to run rampant in Indiana. The likelihood of them being victimized in any of those ways, being murdered, was extremely high to begin with. But it's no wonder. If you notice in the thumbnail, I placed for you the line outside the courthouse on verdict day. All the bloodlusters lined up in a row, only wanting blood, no matter who it is. And they got it. So now life can carry on, and everyone can be happy, and people can stop talking about the Delphi murders, and forget about Flora while you're there. Matter of fact, don't even think about the old Stevensons out in Kentucky. Whatever you do, don't think about the heathens or racists or bike gangs or meth trafficking or human trafficking, because those things don't exist. There's no problem in Indiana. There's no problem in Carroll County. We're all good folks here. Salt of the earth. Stand up, folks, we are. If they tell you human trafficking does not exist, tell them to go fuck themselves. If they say there's no meth problem in Indiana, tell them to go fuck themselves. There's no arson problem in Indiana. There's no racial problem in Indiana. There's no gang problem in Indiana. There's no trafficking problem in Indiana. There's no murder problem in Indiana. There's no white supremacy problem in Indiana. There's no problems in Indiana. Just go somewhere else. Leave us alone. Look the other way. We want this all to go back to normal. No tentacles. Not a single tentacle? The problem is that all these things do exist. All these things are problems. These problems will not go away easily. And people will not stop addressing these problems. So that's why we're here. We're doing God's work. Yes, we are. Despite what anyone will tell you, despite what these black magic, Wiccan, satanic, heathen, occultist, evil motherfuckers will tell you, we're doing God's work. And we know it. So it's only beginning. It's just beginning. Remember, it's only 2024. It's just beginning. We're going to get the Epstein list. We're going to get the P. Diddy list. And we're going to get the Dropbox. Like it or not. And if you don't, ask yourself why not. So I'd like to thank everyone for being here. I know that was quite a long show. It was a lot of work, a lot of reading, but I think it was all worth looking at. And hey, Diener and McClellan and Gull, I have a question. Where is page 8? But I want to thank everyone for being here. Like I said, I really appreciate you. I'm sorry that I did not have the ability to look at or deal with the chat tonight, but I'm sure it was wonderful. We have wonderful mods, wonderful people, members. So I'm confident that you all had an amazing conversation. I will go back and read it when I rewatch the show. And I'm very happy about that. So thanks to all my mods for making sure it's a nice, comfortable place for everyone. And if you're lurking, just join in at the end to say goodbye to all of us. If you're on the replay, please leave a comment, even though you missed the live chat. We need your comments. The comments, this conversation will not stop. It has to continue. So leave a comment. and hit the like. And I want to thank everyone for being here, and especially contributors. Okay, let me show that. Starlight Synchronicity. Thank you, Prof. As awful as it is, we need to keep talking about this. Yes. Just a little thank you, Dream Suburb. Thank you, Shelley Klein. Get good coffee. Exactly. That's what I do. I buy nice organic coffee at Safeway. Mudbug, thanks for buying a membership for someone. And another one. And thanks for a super sticker. Thanks for becoming a member, Housebroken. Thank you. And thank you for Ninja Warrior Assassin for a super chat. Love your channel, Prof. Thank you. And it's a new day. Thank you for a super sticker. And anyone else, if you'd like to support the channel, please hit the Cash App. I put it in the link at the top of the chat, I believe. There's a Cash App. Please support with the Cash App. Please support with the super stickers, the super thanks, the buy me a coffees. Any way you'd like to support us financially, please do so. I need the help. I have just purchased a nice component for the channel, so that will help improve the quality of the channel, and I really am happy about that. So please support the channel and help me pay for equipment. And more than anything, leave a comment down below and hit the thumbs up. That helps. So appreciate everyone for being here. Let me say goodbye to everyone on the way out, because I'm out of here. My throat's shot. It is literally shot. Mystic Firefly, Sweet Dude Shibby, Jenny Grohl, Spike Dog, True Tammy, Coach Cruz, what's up? Amy, Mother McReady, Jay, Miss K, Inner Space, Jules Tully, Radar, Swade Smith, Deputy Dog, Kiki, Shelly Klein, Dream Suburb, Jay, Chris A, Jenny Grohl, Cricket Day, Malibu, True Tammy, Kayla, of course, Housebroken, Crazy Chick 79, Lisa, of course, Starlight, Miss K, Digital, Deputy Dog, Debbie Packer, Kate U, 5 Green Acres, V, Bonnie, Joey, all you guys, okay? Kate U. Anyone else I missed, drop a new comment and I'll see you, because I've gone back. Ban Via, what's up? Appreciate everyone who was here, okay? And if you were here earlier and I missed you, I love you too. Okay, Nancy Drew, thank you. So that was our show for today. Delphi Bloodlust. It needs to end. It needs to come to an end. And I'm confident in the next year, in the next years, it will come to an end. And largely in part to the conversations we're having right here. All right. Okay, God bless everyone. Coach Cruz says a concerned citizen is coming forward. Okay, what's up, Bonnie? Thank you. What's up, Jessica? Thank you. Mary. Okay. All right, you guys, we love you. So I'm out of here. I'm exhausted. What's up, Judy Hathaway? And look, Amy's putting up the support pathways. There you go. Please support the channel. Appreciate it. Anyway, thank you all so much. We will see you on another show. So God bless. And remember, if you haven't made yourself familiar with the Frank's Memorandum, check out the Frank's Memorandum Deep Dive live. The Frank's Memorandum, it's in my playlist. It's really good. It's a long document, and so it takes hours and hours, but you should get to know the document. It's there. And anyway, shout out to all you locals and all you attorneys and all you YouTubers and everyone who I speak with regularly who helps me keep going. Thank you so much, okay? Oh, and a special shout out to my buddy Four Pits. I want to show you something. Four Pits sent my little boy a geode. Indiana geode. And look at it. So thanks 4 Pits for the crystals and the geode. It's very nice. My son loves it. Anyway, God bless everyone. I'm out of here.